All right, welcome everyone. I'm Caroline Cecot, a professor here at Scalia Law, and I'm excited to introduce you to our last set of panelists here. We'll start with the paper presenters, and up first we'll have Ambassador C. Boyden Gray, who is the founding partner of Boyden Gray and Associates, and who previously worked in the Reagan, George H.W. Bush, and George W. Bush administrations. Then we'll have Scalia's own Professor Adam White, who is the director of the Center for the Study of the Administrative State here. And we're also glad to have Professor Robert Glicksman here from GW Law School and Professor Nathan Richardson from the University of South Carolina School of Law as discussants. So we all agree that we want to maximize discussion and audience participation. So I'll be here to make sure no one goes over 15 minutes, and maybe I'll sneak in a question or two, but you start thinking of questions for our panelists, and let's get started. So, Ambassador Gray.
Can you hear me?
Yes.
I always worry about my height because I can't judge hotels by the height of the shower head. I had an ancestor who was 6'8" before the Civil War, who was in Congress and who was challenged to a duel by a very short congressman who was very cocky. And my ancestor said, okay, broadswords in the middle of the Potomac. Which didn't go so well for the little guy. Anyway, creative rulemaking. There are two examples which I want to delve into a little bit about regulation of cars and trucks and buses by EPA. The first has to do with the CAFE standards, corporate average fuel economy, and the second has to do with the VW fiasco of the emissions cheating and the remedies that EPA imposed. Both quite creative, both really, I think, beyond anything Congress contemplated, and both, I think, ultimately, at least to date, quite unsuccessful. The first is really an extraordinary tale of blackmail, regulatory blackmail, where the EPA connived with with CARB, Mary Nichols, who had been an air administrator at EPA in an earlier incarnation. She was importuned to propose a California CO2 climate change car, for which she was preempted, from which she was preempted by the CAFE statute, EPCA, as far as that's concerned, and I think also violated the restrictions of the Clean Air Act itself under EPA. So you had two separate departments of the government under two separate statutes saying you couldn't do this, but they did it, and the threat was, we will stick with this, which was existential for the car industry. It's one thing to require differing catalytic converters on different cars. It's another thing to go to the very structure, wheelbase, the very structure of the car itself, and you can't really make two separate car lines in the country. And while only only California has the right to differ from national standards, states can follow exactly what California does. So, a half a dozen, then later a dozen states kind of joined in, and it looked impossible. The deal was, if you agree in advance to everything we're going to do to you, this is EPA speaking, everything we're going to do to you by way of corporate average fuel economy standards, we will talk California into deferring to our CAFE rules, our efficiency rules. And so that was the deal. And this is nothing secret. The Ford letter complying with this blackmail is in the Federal Register, quite detailed, quite extraordinary. The preclusion of judicial review lasted for the entire Obama administration and included challenging whether or not California had the authority to issue any rules at all given or propose or even threaten any rules at all given the very, very explicit preemption of the EPCA statute. As a result, there was no judicial review of the CAFE rules. And so you might say, well, what difference does that make? Well, one of the things that happened in the process of this blackmail is that EPA single-handedly by itself reversed some congressional authorization given to the National Highway Traffic Safety Administration under the Department of Transportation to favor, as the statute was originally designed to do, domestic fuels, because it was about energy independence, not about climate change per se. And one of the provisions would have given an incentive for natural gas vehicles, which are probably only viable for fleet vehicles that go back to a centrally fueled location. But fleet vehicles do most of the driving during the daytime in most cities, and so are responsible for a huge hunk of the pollution, even if it's not a high number of vehicles. 30% of all Ford Motor Company sales are to fleet buyers, not to individuals like us in the room here. And had just half of that 30% gone to buyers who were using natural gas as a fuel for the cable guy or the telephone guy or the flour deliverer or whatever your delivery van is called, could have shaved 6 mpg off the mileage requirement, which is worth I don't know how many tens of billions of dollars in potential liability and potential tradable credits. This was in the DOT rule. It is in the DOT rule, but it is made impossible by the EPA rule under the Clean Air Act, and other things as well. But I use that as one example. Where EPA gets the authority, a much older statute, displacing a much later and more specific statute. Where EPA gets the authority, I don't know. It would have made a very interesting lawsuit, but there was no way for the car companies to challenge it. One could look at this and say, well, but gee whiz, climate change is really quite important, and we shouldn't be playing games with it. And the only thing I would say is that the success of this program up to date has resulted in the last 2 years being the highest years of highest automobile gasoline fuel consumption in the history of the United States. It's peaked since this program was implemented. So you can see how successful it has been in conserving resources and in reducing CO2, to say nothing of the other pollutants that have been sacrificed as well. I don't know that many people really understand that EPA ripped up some statutory authorization But we will never know what would happen to a case because they were prohibited from exercising their rights of judicial review in order to avoid the threat of a separate California car. The other example that I want to use, I think equally unauthorized and will be equally unsuccessful, is the EPA's taking a really sort of bad faith effort by VW to cheat on our tests to the tune of, some $50 billion in fines, and to take some of that money and direct it towards the installation of electric refueling stations. Now, this is an application of favoritism towards one possible solution to the climate change issue. Electric cars are one possible solution. There are many others, natural gas cars being one of them, cars fueled by biofuels being another, hydrogen. There are all kinds of different possibilities over the next 2 or 3 or 4 decades, but to pick an electric car and give it regulatory favoritism, it gets regulatory favoritism under the CAFE rules as well. To pick that as the winner is, of course, contrary to all the level playing field competitive rules principles that we think we have learned or should have learned since the days of the early Reagan years, if not even the late Carter years, in terms of regulatory reform. The Congress rejected an explicit electric car only solution to this. So not only was EPA not authorized to do it, it was prohibited, in a sense, from doing it. But it went ahead and did it anyway. We'll see how successful it is. Every time I think of, or get into cold weather like this, I thank God I don't have an electric car, because cold reduces the car battery life. And it's like you start out in the morning with a full tank of gas and you find you can't get home because you only have 1/8 of a tank of gas. Now, that's what cold does. And so we really should get back to global warming as quickly as we can to make these electric cars work. And without global warming, I don't know whether they're viable or not. In any event, these are two of the examples that, and there are many others, but these are two pretty egregious examples of creative action by an agency to force a helpless regulatee from taking any review action to question this kind of activity. Using slush fund money from settlements for expenditures not appropriated by Congress probably violates the Constitution and the congressional hegemony over overspending, but we don't know because we have yet to see the possibility of a real challenge. Now, I think that under Administrator Pruitt, we won't see such creativity. He's going to try to go back to the main job that EPA was set up for, which is getting into attainment for criteria pollutants and cleaning up Superfund sites. He's going to focus on the meat and potatoes of the agency and not a lot of exotic stuff. I would only add as a footnote that it doesn't really bother me that VW got a little bit of yanking around, because they have criticized us as being environmental scofflaws, as Europe generally. I think it's not totally inappropriate that they should watch what they do over here. We don't send cars over there to violate their laws. The European attitude about this has always struck me as a little bit odd, and I was Ambassador to Europe. I didn't want to say that was one of my assignments. But I remember once being in Bali for a climate change session where, of course, cars were a big part. And we were being asked to do something by the reigning powers that be, the Europeans mainly, that we simply couldn't comply with. And I was yanked out of some meeting by some very, very pompous British diplomat who said to me, why can't you do this? This is critical to the future of the world. And I said, well, we can't do it because we can't meet the standard, and we're not going to agree to do something we cannot physically, chemically, electronically, mathematically do. We can't comply. And he said, comply? Comply? Who's talking about compliance? It's only a piece of paper.
So I was chatting with Boyden right before the panel, and I mentioned that we're particularly well suited to present on this topic. He's gray, I'm white, and neither of us is very green. It's a real pleasure to be here, along with Rob and Nathan, two scholars I admire. Many thanks to the Law and Economics Center for hosting this, to the Federalist Society's Regulatory Transparencies Project, and thanks especially to the student editors of the JLEP. I'm very, very proud and pleased to be a part of this project. I co-authored a paper with two friends, Darren Baxt and Mark Rutzik, for the RTP project. We wrote a paper on the Waters of the United States standard, rule that was implemented by the last administration. It's being reformed right now, and so that's what I'll be speaking about. I don't know about you, but when I think about administrative law and regulation, I tend to get quite poetic. And in thinking about this topic, I was reminded of one of my favorite poets, somebody who grew up on the Mississippi River like I did, T.S. Eliot. He remarks in 4 quartets, he says, "The river is within us, the sea is all about us." It's very poetic, but it's no way to run a country. And that resembles all too closely the EPA's approach to administering the Clean Water Act. The river is within us and the sea is all about us. I'd say that the Clean Water Act is a little bit more specific than that. And the EPA should probably, and the Army Corps of Engineers, should treat it as being more specific than that, than assuming the waters of the United States is basically everything within and around us. Now, to be clear, I don't envy the EPA or the Army Corps in their joint task of administering the Clean Water Act. I mean, that statute, as in so many others, Congress directed the agencies to undertake countless tasks, oftentimes under too tight deadlines, with too little resources, too little money. And Congress heralded its passage of the act in '72 with statements of policy, grand statements of policy, like it is the national goal that the discharge of pollutants into the navigable waters be eliminated by 1985. Spoiler alert, it didn't happen. Or Congress said that agencies should, quote, restore and maintain the chemical, physical, and biological integrity of the nation's waters. Again, a very broad pronouncement, but too broad. And when the actual operative law comes up later in the act, Congress is more specific. They say that the agencies are supposed to prevent discharges into, quote, navigable waters, which they then define as the waters of the United States. When the Clean Water Act was enacted in 1972, you fast forward 43 years, you get to the EPA and the Army Corps' Clean Water Rule. And what do they say qualifies as a navigable river under the Clean Water Act? Well, they say it's defined as waters of the United States under the statute, and that includes traditional navigable waters, interstate waters, territorial seas. And then beyond that, it includes tributaries and adjacent waters and intermittent streams. And you keep going further down the list, you get to things like ephemeral streams. And even in sort of the fine print, you get to man-made ditches that might qualify as waters of the United States that can be regulated by the EPA pursuant to power given to it by Congress under a constitution that limits Congress's authority to, in this case, regulating commerce among the states. Now, the EPA and Army Corps' broad view of this policy might make sense if the agency's job was to protect the quality of every body of water wherever found. With that job, it might make sense to regulate patches of land or ditches that are nearly even dry, just because they are sometimes a little damp. But again, this is no way to run a country. More specifically, it's no way to administer a statute. The Supreme Court says over and over again, an agency has literally no power to act unless and until Congress confers power upon it. And in turn, when Congress's own authority, Congress's own authority to confer power upon an agency is limited by the Constitution. So when federal agencies undertake a program, they need to faithfully administer the law that Congress wrote and to take care to understand that law in light of the constitutional principles that undergird it. Now, as my co-authors and I venture to explain in this white paper, the EPA and the Army Corps fell far short of this task in their 2015 rulemaking. Again, in the Clean Water Act, Congress directed the agencies to regulate discharges into, quote, navigable waters, which in turn they defined in 33 U.S.C. 1261 as the waters of the United States. Well, what does that mean? The EPA and the Army Corps have spent decades trying to grapple with this term, try to understand how best to interpret it, how best to construe it. But their work reflects the fact that they focused far too much on the word waters generally, and not nearly enough time thinking seriously about what Congress meant by the waters of the United States, or navigable waters. On its face, those terms seem to imply more than just any water wherever found. And the EPA, to be fair, the EPA and the Army Corps did narrow their interpretation somewhat beyond just any water per se, but they didn't go nearly far enough in limiting their interpretation. In fact, as you read the 2015 rule, it quickly becomes clear that whatever the EPA and Army Corps thought they were doing, they certainly weren't trying to limit themselves to genuinely navigable waters, which again is the operative statutory term. Remember, the waters of the United States was the definition for that operative statutory term, navigable waters. And yes, the waters of the United States is a very broad term, but that term, the waters of the United States, was meant to define navigable waters, something much more specific. And so I think Justice Scalia was right when he wrote for the plurality in the Rapanos case in 2005, saying that, quote, on its only plausible interpretation, the phrase waters of the United States includes only those relatively permanent, standing, or continuously flowing bodies of water, and not mere, quote, channels through which water flows intermittently or ephemerally, or channels that periodically provide drainage for rainfall. I think that's probably the best way to interpret the statute on its own face. At the very least, I think it's the best way to interpret the statute against the backdrop of the much, much longer constitutional history that preceded the enactment of the Clean Water Act. This constitutional foundation, this well-established foundation that Congress was building upon when it created the Clean Water Act and delegated power to these agencies. Now remember, the Constitution doesn't give Congress plenary power to regulate and to protect the environment. Rather, it gives Congress authority to, quote, regulate commerce with foreign nations and among the several states. In 1837, the Supreme Court recognized that this constitutional power included the power to regulate navigable waters. What does that mean, navigable waters? Well, under English common law, navigable waters meant basically tidal waters, waters that were influenced by the ebb and flow of tides. That might have made sense in England, but of course, England is, in the words of Bill Bryson, a small island. Here in a large continental nation, it's understandable that navigable waters mean more than just things that are subject to the tide. Again, I grew up on the Mississippi River. I know full well it's very navigable, even in the winter when you drive on top of it. But it's not subject to the tides, at least not in eastern Iowa. So the Supreme Court recognized in 1870 that navigable waters would mean more than just tidal waters. It would include waters that were actually navigated or readily susceptible to being navigated. And that history embodied in those early cases was reflected in laws like the Rivers and Harbors Act of 1899 and all the other laws of the 19th century into the 20th century where Congress administered that power to regulate navigable waters. Now, needless to say, I welcome the EPA and Army Corps' recent efforts to reform and improve their interpretation of the Clean Water Act, to bring it back to something more closely resembling that traditional understanding of what navigable waters is. I think that has to be the starting point for any regulatory discussion on how to implement the Clean Water Act. The starting point is not just environmental protection, which of course is one of the most important values of our time, but before that it has to begin with a good faith investigation into what the statute means in light of the constitutional history upon which it builds. Let me just go a bit further in terms of the recent reform effort. Not only do I welcome in general the EPA and Army Corps' efforts to reform this rule, I welcome the way in which it started with Executive Order 13778, one of the early executive orders that came out of the President Trump administration. In that executive order, President Trump directed the agencies to begin to reform these rules, directed the agencies to consider, in their interpretation of the law, Justice Scalia's definition from the Rapanos case. The president gave meaningful guidance to the agencies and kick-started or jump-started a reform process. I actually think that's probably the right way to do these things, not just on this issue in particular, but in lots of regulatory issues. I think it's a good thing that the president and the White House paid attention to this and then tried to take the first step in the reform process. I discussed this in an upcoming contribution to a symposium at the Notre Dame Law Review, where I say that above the table, presidential involvement in rulemaking is a good thing. There's drawbacks to it, of course, they need to be considered, but on the whole, the president's expressed transparent involvement in this, in starting this process, is a good thing. It calls to mind Hamilton's discussion in Federalist 78 that energy in the executive is a leading character of good government, not just in foreign policy and national affairs, but also a leading quality of good government at home in the steady administration of the laws. And more than that, the Supreme Court now has, for more than a generation, premised modern administrative law on the idea that the agencies are accountable to the people through the president, and that the president is a central figure in the administration of laws. So much of this happens, behind closed doors, behind the scenes, with presidents either telling their agency heads what they want them to do or strongly implying what they want them to do. I think it's better when this is done out loud in the open in executive orders, where accountability then is traced all the way back to the president himself and not just to agency bureaucracy or to the agency heads. So I think it's a welcome development that the White House began this process with an executive order. I think it's a welcome development that the agencies are now going forward with that process, attuned to the direction of the president in that executive order, and I think better attuned to the constitutional values that underline all of this. I think the agencies are off to a good start. I hope it ends on an equally positive note. Our environment deserves to be protected, but so does our Constitution. Thank you.
Good afternoon. I want to thank the Law School and the Journal for inviting me. In the second panel this morning, Brenda said she wasn't quite sure what her role was on that panel. I think I understand what my role is supposed to be on this panel. It's supposed to be that of critic and dissenter, and I'll try and play that role to the hilt. I think both papers display a somewhat cramped view of administrative and prosecutorial discretion that doesn't correspond to my understanding of prevailing administrative law and separation of powers doctrines. To begin with Ambassador Gray's paper, I disagree that the environmental examples that he analyzes reflect impermissible coercion of regulated entities or that they lacked independent oversight. To begin with process, the paper asserts that the Obama administration's CAFE standards were negotiated in secret. But in adopting both earlier and later standards, EPA and NHTSA held public hearings and received hundreds of thousands of comments from interested stakeholders. The agencies also met with many different stakeholder groups during the public comment period and significantly placed memoranda summarizing these meetings in the rulemaking docket. I do agree with Ambassador Gray that precluding judicial review by statute is generally undesirable, but I would note that many bills recently introduced in Congress this session, including some infrastructure development, would do exactly that. The paper attacks the Obama administration for deliberately encouraging California to establish a two-car regulatory patchwork and then using the enticement of a single national standard to strip automakers of legal rights. The so-called patchwork is, of course, the product of deliberate congressional compromise and choice in 1977, rather than something that EPA invented. Congress preempted all states except California from adopting their own tailpipe emission standards precisely to avoid a regulatory patchwork. But it authorized California to grant, EPA to grant waivers from that prohibition to California based on California's trailblazing role in regulating tailpipe emissions in the 1960s, as well as the state's unique auto pollution-related problems. Since the enactment of Section 209 of the Clean Air Act, EPA has issued more than 50 waivers and only once has denied a waiver request, and that denial was reversed. The paper implies that something was wrong with EPA's swift change of course in reversing the 2008 denial, but by that logic, EPA's ongoing efforts to repeal the Clean Power Plan also should be regarded as suspect. In any event, the so-called patchwork and balkanized vehicle market is limited to 2 standards, not 50, and it accommodates the state's policymaking discretion and public health needs in precisely the way that Congress anticipated. A recent federal appellate court decision makes this clear. It said that, notwithstanding the auto industry's adamant complaints that it needed a single national standard, now I'll quote from the decision, Congress decided to encourage California to continue and expand its pioneering efforts at adopting and enforcing emission standards different from and in large measure more advanced than the corresponding federal program. In short, to act as a kind of laboratory of innovation. Continuing the quote, so California's role as a leader in developing air quality standards has been explicitly endorsed by Congress in the face of warnings about a fragmented national market. As I understand the paper, and I may be misunderstanding here, it criticizes the government for improperly using threats to impose coercive requirements on the auto industry. I don't find the analogy to a protection racket or to blackmail compelling. The administration supposedly exercised improper leverage in negotiating the bailout after the 2008 crash to force the auto industry to submit to the government's demands concerning fuel economy requirements. Well, the Treasury Department invested billions of dollars in Chrysler, Ford, and GM. It doesn't seem inappropriate to extract commitments in return, and that some of these commitments related to fuel efficiency seems to represent a reasonable exercise of the federal spending power. Chrysler asked for $6 billion from the Energy Department precisely to retool for more energy-efficient vehicles. It wanted, it said, to partner with the federal government to develop alternative energy vehicles and pledged to debut an electric vehicle in 2010. Likewise, in 2009, Ford received about $6 billion in loan money from DOE in return for pledging to accelerate development of hybrid and battery-powered vehicles. Its CEO explained that, quote, we want to become a top player in electrified solutions. The company wants to lead. By one estimate, the bailout created $340,000 jobs in the auto industry. Paper's criticism of the VW settlement is, I think, hard for me to understand. It criticizes the settlement on the ground that making investments in zero-emission vehicles was not in VW's interest. Well, sometimes individual corporate and national interests diverge, and that's one reason we have regulation. One official at the Florida Department of Transportation recently remarked that it's a rare occasion that an environmental incident gathers such unanimity as the outcome of the VW scandal. Paper also criticizes the settlement as having compelled VW to agree to EPA's demands. Well, VW admittedly broke the law, was the subject of an enforcement action, and negotiated a consent agreement to settle the charges. Its decision to settle instead of contesting the charges doesn't amount to improper government coercion. By that logic, all plea bargaining is improper government compulsion. A prosecutor's agreement to impose public service requirements in exchange for dropping or reducing criminal charges would be an abuse of his or her authority. A federal judge who approved the consent decree determined that it resulted from non-collusive and adversarial negotiations. He said it was negotiated by the parties in good faith and will avoid litigation among the parties, and further, that it was fair, reasonable, and in the public interest. I think the paper's claim that there was no independent oversight is therefore inaccurate. Judge Richard Posner, formerly of the Seventh Circuit, has characterized the settlement of any litigation as basically a bargained exchange between the litigants, and has argued that judges should not substitute their own judgment as to optimal settlement terms for the judgment of the litigants and their counsel. One law and economics text explains that a settlement is a contract whose existence reflects the conclusion by both parties that they're better off with than without it. And that dynamic, it seems to me, applies in the VW case. Finally, I don't think that Congress's consideration of but failure to adopt a zero-emission vehicle program like the one that arose from the settlement is dispositive of EPA's authority to negotiate for one. In Massachusetts versus EPA, the Supreme Court concluded that Congress's failure to adopt a program to control greenhouse gas emissions did not strip EPA of its authority to do so. As in that case, there's nothing counterintuitive in EPA's effort to limit pollutants of the kind that VW's vehicles emitted by fostering investments in low or no emission vehicles. That reasoning is consistent with the Court's disinclination in Massachusetts and other cases to attribute meaning to congressional inaction, given the multitude of reasons that Congress might have not to adopt a particular statutory provision or program. Let me just say a few words about Adam White's paper. First of all, I think that EPA is indeed demonstrating creativity under Administrator Pruitt, such as in deferring the Waters of the United States rule for 2 years based upon what it calls an extended applicability date, which it distinguishes from the rule's effective date. But to get to the paper uses the Supreme Court's decision in the Daniel Ball case as the touchstone of navigability. But I think that reference point is problematic. As the Supreme Court recognized in the Riverside Bayview case, Congress intended the term navigable waters to include at least some waters that would not be deemed navigable under the classical understanding of that term. Indeed, one of the cases cited in the paper, the Nelson case, was an admiralty case in which the court concluded that the fact that rivers are sometimes unnavigable cannot affect their navigability at other times. Even if traditional navigability were the test, the Supreme Court pointed out in the 2012 decision in the PPL Montana case that different versions of the navigability test apply in different contexts. It noted, for example, that the version that applies in determining the extent of federal regulatory authority is broader than the one that applies under the equal footing doctrine. I agree with Adam that the term waters of the United States has been problematic. Chief Justice Roberts in Rapanos criticized Congress, EPA, and the Corps for that lack of clarity. The 2015 Waters Rule of the Obama administration was its effort to clarify that definition in response to Chief Justice Roberts' criticism. There's no question that the meaning of the term remains obscure in some cases, and I think in part that's because Justice Kennedy's significant nexus test in Rapanos is necessarily highly contextual. I would note that even some industry critics of the Obama rule are skittish about replacing the rule with one based entirely on Justice Scalia's plurality opinion in that case. Finally, I don't agree with all of the paper's characterizations of the 2015 rule. For example, the rule excludes coverage of ditches with ephemeral or intermittent flow that are not relocated tributaries or excavated in a tributary. It excludes artificial stock watering ponds, even if EPA misapplied the regulations in the Johnson case cited in the paper. In some respects, indeed, I think the rule is excessively narrow. It, for example, excluded certain waters, like groundwater that's hydrologically connected to covered surface waters. There's some disagreement among the federal courts on whether groundwater is covered by the Clean Water Act, but a substantial number of decisions have concluded that it is, if it's hydrologically connected to jurisdictional surface water. And as I was waiting to attend the conference this morning, I noted in my inbox that the Ninth Circuit issued a decision yesterday that seems to endorse that proposition, though I haven't read it yet, so I can't say for sure.
Thanks everybody. Thanks for sticking around in the afternoon. Again, I'm Nathan Richardson. I want to say thanks to the George Mason Law School, to the Antonin Scalia Law School, and to the Federalist Society as well for having me, and to the two authors of the paper for giving me a chance to respond to their work. My general reaction to both papers is similar. I think there's some underlying rule of law or liberty concerns that are motivating the papers, and I'm broadly sympathetic to those type of concerns, but I don't think that things are as bad as the papers suggest. And some of the reasons are exactly the same as those that Rob mentioned. I broadly agree with everything he said. In fact, I appreciate going after him because it lets me focus on other things that I want to critique in the paper. I also appreciate going after him for another reason that I'll mention in a minute. Not only do I think things aren't as bad as the papers suggest in many respects, I think the solutions available, either mentioned in the paper or not mentioned in the paper, might in fact make things worse, either for environmental reasons or rule of law reasons or both. But the specific reasons why I come to that conclusion, even though I share it across both papers, are different in the two different cases. So let me talk about the papers, and I'll talk about Ambassador Gray's paper first. Again, I'm sympathetic to the rule of law concerns that are motivating this fear or this observation of a possible agency overreach, possible breach of the rule of law, or agency arbitrary action. But the two environmental examples in the paper don't particularly bother me very much, at least relative to take, for example, the choke point example that is mentioned in the paper and was discussed earlier today. And I can't be sure, but I don't think the reasons why my feelings are different are because I might care more about the environment than I do about consumer financial issues. That's what I'm expert in and tend to research more. But I don't think that's what's driving it. I think there are material differences in the examples. So let me talk about the two examples. So the U.S. car maker story, I think Rob's given a great summary there. But let me focus on one point that he made, which is the context in which this concession by the car makers was made, and that is specifically the United States government's large bailout investment in those companies. If you think of the government as an investor, it is not a surprise that a distressed company might have some conditions imposed on it by the one investor that can save that company. And I don't have any particular rule of law objection when that investor happens to be the government versus some private party. So that doesn't come as a surprise to me. Alternatively, if you consider the bailout not as so much as an investment, but as a government benefit, it is much less concerning from a rule of law perspective if the government conditions the benefits that it gives than if it does than when it imposes regulatory conditions for which you'd want congressional authorization and judicial review, et cetera. To maybe be slightly provocative, if we can condition Medicaid benefits on working, then why is it now all of a sudden a big problem to condition multi-billion-dollar auto industry bailouts on compliance with pre-existing CAFE standards? And in fact, as part of an agreement that unifies CAFE standards and has one national standard, which of course the auto industry has always wanted. So that doesn't trouble me particularly. The VW example, the Volkswagen example, also doesn't trouble me. And let me try to illustrate why by differentiating it from the choke point example we heard earlier today. So in the first panel, we discussed the choke point example, and there were two differing accounts. One, or essentially the administration account that we heard from Mr. Vladek was essentially this is about going after scams, it's going after bad actors, therefore we shouldn't have to worry about it so much. And the other was that this was an underhanded and backdoor way of attacking disfavored but fundamentally legal businesses. And I agree that depending on which one of those accounts you find more plausible, that probably drives a lot of your concern about whether choke point troubles you. Well, here we don't have that issue. Everyone agrees that VW is a bad actor. At first. Now, just because you're a bad actor, just because you violated the law, doesn't of course entitle the government to do anything they want to you. I don't mean to suggest that, but we don't have that distinction there. The other, also again, as Rob mentioned, is that this is a settlement deal. VW doesn't have to take this deal. They can say, see it to EPA, take the penalties and take their hits. Maybe you think the penalties are too harsh, so harsh, in fact, that it's effectively compulsory to engage in this kind of settlement. But if so, then again, as Rob pointed out, then I suggest looking at the plea bargains that dominate our criminal justice system and suggest that you probably would have problems there too. That doesn't mean this is okay, by the way, but for intellectual consistency, you should probably be worried about that. And again, because this consent decree was reviewed reviewed by a judge, we should have maybe a little less fear that this is the kind of compulsion, kind of imbalance of power that would tarnish a settlement agreement. Generally, for all the reasons, again, that Rob mentioned, we're taught as lawyers, or at least as law professors, to teach our students that settlements are good. Litigation is expensive, lawyers are expensive. It's generally better when parties in a dispute come to a contract among themselves to resolve that dispute. Shouldn't that be what we want in the regulatory context too? And if so, then at what point, if any, does that become a problem? Maybe it becomes a problem when there's too much coercion, when government has too much power relative to an actor. But this is, yeah, the United States government is powerful, but this is the largest car maker in the world, or at least it was at the time, my understanding of the litigation. So the power imbalance isn't that great. I also suspect people who think this is too compulsive to VW or an abuse of government power may not take the same view, for example, of the CFPB's attempts to reduce the use of arbitration clauses, where there's also a imbalance of power between consumers. So again, for consistency, if imbalance of power is the reason why you think sub-settlements are problematic, then consider, if you may have, consider a difference of opinion in those issues. And moreover, even if we want to set some limits on government's ability to settle in these kind of regulatory cases, the paper doesn't discuss what those limits should be or what the alternative should be. So let me suggest some possibilities. So one possibility is you say you don't want the government to settle at all. The statute says what the penalties are for the breach of certain environmental laws, and that's the end of it. Basically, companies have to pay those fines. The fines are quite high in the Clean Water Act and in the Clean Air Act. I think you see that. Essentially, BP in the Deepwater Horizon incident and VW in this example felt that it was to their advantage to settle. Maybe they would have preferred different terms. I'm sure they would have. But if we don't allow them to settle, that's a much greater hit to corporate behavior. I'm not sure, if I put my environmentalist hat on, I might actually support that view. Don't settle. I want the full penalties. I doubt that's Ambassador Gray's view. It might be, but the paper doesn't say what we should have. So let me offer another possibility. Maybe the concern isn't about coercion, but it's about what government does with that power to settle. And then you could say, as a way to resolve it, maybe any settlement agreement funds go not to the relevant agency, but go directly to the Treasury. In fact, there's some interpretations of current law that would suggest that that's probably that probably should be the result anyway. I'm more sympathetic to that. But to the extent that reduces the incentive of the agency to settle, you might worry you get fewer settlements. Let me just footnote that as somewhere where we need more discussion. I think anytime you restrict the ability of the agency to settle, though, you run a real serious risk, though, of having worse outcomes than you do under the current system, even if it does occasionally trigger worries of coercion when the power imbalance is great. Again, in this circumstance, VW, EPA, we know VW is a wrongdoer. I'm just not that worried about the imbalance of power. You might be able to identify a case where you have a smaller wrongdoer where that would make me more concerned, but this one isn't it. All right, let me talk about Adams' paper on the waters in the United States. And again, this is a paper where I understand and I'm sympathetic to a lot of the motivating concerns, but I don't think the problem's as bad as it's characterized, and in fact, I think solutions might make things worse. Fundamentally, this part of the Clean Water Act and the Waters in the United States rule, the navigable waters issue, is a line drawing problem. And it's not even your traditional two-way line drawing problem. It's a three-way line drawing problem. And let me try to illustrate. So there's an ecological view under which understands that everything is connected. In fact, in particular, that wetlands are connected. Wetlands provide specific and valuable ecosystem services above usually greater than those provided by most other lands. Not just species, but things like flood protection, and therefore deserve some level of protection. And the line at which they don't deserve that protection is very difficult to define, and not only very difficult to define, but it's very small. Even wetlands that are only wet for part of the year might provide very valuable ecosystem services. To illustrate, take flood protection. So you've got a wetland, again, some people might not call it a wetland, but an area on your land that's only wet part of the year. If the main ecosystem service that it provides is flood protection, well, guess what? The time of year when it's going to be wet is when it's providing that ecosystem service. So if the law allows you to fill that in, you lose all the benefits of that. This is a line, to give the other view, of course, that's the traditional common sense property owners' view that government should stay out of what we want to do on our private property as much as possible, and can only justify regulation when the public benefits exceed the private costs. And our commons, that's the economic view of it, but our common sense view is that regulating things that are very small or man-made or only wet part of the year are on the that's too much regulation side of it. And that's in tension with the ecological understanding. This line is difficult to draw. It's an old line. It has roots all the way back to the development of nuisance law and common law property. What is too much regulation? When have you hurt other landowners too much that the law will limit what you do? That line has never been precisely drawn, and it's very ambitious to try to do so now. It's even more difficult when you add a third line, and of course that's the constitutional line that Adam spent so much time talking about. If it were clear where the limits of constitutional authority of the federal government were in terms of regulating waterways, we would know by now. We don't. I don't know what they are. Adam and I might disagree, but I don't know what they are. He doesn't know what they are, and the Supreme Court can't figure out what they are either. I wish we had more precision on that. Congress didn't decide the trade-offs between these three between these three different principles when it wrote the Clean Water Act. I don't think I can come up with a better example of the kind of arguably dereliction of duty in writing environmental statutes that our lunchtime speakers talked about than this kind of lack of clarity over decades. Congress needs to revisit this issue. I think the fact that we have been debating this issue in forums like this and in the Supreme Court and other venues for decades shows that need. I think in a candid moment, both environmentalists and private property activists would, and landowners would agree that there needs to be more clarity from Congress on this. They might very much disagree about where that line should be drawn, but I think they both need more clarity. It's frankly embarrassing as a country that it's taken us so long to try to decide this issue. It's difficult for me as an environmental law professor. I have to teach this series of cases and then look at my students at the end of it and say, I don't know either. However, for all the reasons, for the political and institutional reasons that our lunchtime speaker pointed out, begging for Congress to solve the problem may not be successful. Therefore, the Army Corps and EPA's solution was to do the best that they could given the conflicting Supreme Court precedents in the Waters of the United States rule. Could they have picked a different line? Yeah, I think they could, consistent with those precedents. I don't think the Waters of the United States rule is egregiously wrong as Rob, or a misreading of those precedents in any way. And I think if we're forced to reopen that issue, that things could get worse. As Rob pointed out, some companies prefer the Waters of the United States rule to, large landowner companies prefer that rule to repealing it. It's certainly possible that we could come up with another round of technical fixes, which would inevitably lead to another round of litigation. I suspect the optimal and politically acceptable balance, if we could get Congress to focus on this, is probably not that different from the Waters of the United States rule. And I think the reason that it inspires so much controversy is because not it's wrong-headed or does a bad job, it's that these ecological and property rights concerns are inevitably going to be in tension. The landowner community has really changed over the last 20, 30 years to come to understand the value of at least some level of wetlands protection. I've seen that in the tree farmer landowners in my own family and in talking to larger landowners as well. I suspect that will continue to evolve, but that won't remove the tension. That will still be there. I think the legal debates that we're having here about where's that constitutional line are largely a sideshow that prevents us. It forces, when we have debates about where the constitutional boundaries are, I'm not suggesting those aren't important from a legal point of view, but it's a way to avoid asking the fundamental question of what is the trade-off between ecology and landowner rights that we're not engaging with and ultimately the political branches need to. Thanks.
Okay, great. So I want to give our paper presenters, Ambassador Gray and Professor White, an opportunity to spend just a few minutes to respond to any points before we open it up to the audience.
A couple of quick sort of thoughts about appeal rights. I don't much like it, even when Congress does it. But I would much prefer Congress to do it than an agency to do it on its own without congressional authority. On the question of the patchwork, and the waivers given to the state of California under the Clean Air Act, I didn't really emphasize that very much because the EPCA statute's preemption provision is so much more ironclad, tight, and seemingly unbreakable, and I just don't see how that would have ever survived the court challenge, which of course the car companies couldn't make. The question about California being given special leeway under the Clean Air Act, it makes sense. It's got the worst situation there in the LA Basin, but CO2 is not a criteria pollutant and never will be. And there's nothing special about California and CO2 the way there is about California and ozone or PM. It's just not a criteria pollutant, and EPA is never going to make it one. Massachusetts versus EPA says that Congress already has authority to move, doesn't have to, but has the authority and can move under the existing Clean Air Act rules. It wasn't saying the EPA could act without congressional authority. It said that the Clean Air Act granted it authority. And AEP versus Connecticut, a case that followed not long after in the Supreme Court, reiterated this point by saying that the Clean Air Act authorities, even though unused at that stage, displaced federal common law. The subsidy arguments, they're in the paper. We don't really deal in the paper, and not here either, with the fact that Ford didn't get any bailout because it had the wisdom to borrow or set up a line of credit before the crash hit. But it did get some favoritism. It got a little back-ending of the rules affecting its largest selling and most profitable vehicle. And that isn't a level playing field either. The settlement question, I'm not criticizing, or the paper doesn't criticize the notion of settlements. It just criticizes this particular settlement as being, as achieving ends that couldn't have been achieved through ordinary rulemaking or other open notice and comment processes. There is, of course, a major difference between the average plea bargain and this. The average plea, unless he's a real recidivist, the average criminal plea bargainer isn't going to be subject to continuing jurisdiction the way car companies are. The desire not to really tick off your regulator is a very powerful one. I don't think that violations of the Appropriations Clause are to be favored, even if they might enable some settlements.
Let me just pick up on one of Nathan's last closing points, because it's an area where I actually agree a lot. Congress does need to do more. I think Congress, in using the term navigable waters, was reasonably clear, but we have seen in the last 40 years that even if, I think it's reasonably clear, other people disagree, and there's been litigation now for decades. And so, yeah, I do think Congress should return to that. I think it's important. I actually think that the existence, let me put this another way. I think that the last 40 years of just handing this issue off to agencies and the courts really leaving the agencies too much running room in this actually undermines and deforms the legislative debate. One of the reasons, it's not just that Congress is inactive and gridlocked over here and the administrative state is chugging along over here and these two things are unrelated. I think there's a deep connection between the two. I think the fact that any legislative debate can end in a stalemate because the president's party knows the president can take care of it himself, that undermines the debate in Congress. And by the same token, critics of the president in Congress know that there's no real reason to strike a deal, to compromise, because they know that the president's party in Congress can walk away from the table at any point and just implement the policy unilaterally, right? That's why, one of the reasons I think why the climate change legislation never went anywhere, not just because I think it was unpopular, but also because everybody in Congress knew that the EPA could do what it was going to do. There's never going to be meaningful legislation on net neutrality, so long as half of Congress knows that their party, that their president can unilaterally sort of manage the process in the agencies. And so I think that leaving the agencies this much discretion actually undermines and helps to cause the legislative gridlock we see. I just want to say that right off the bat. Rob pointed out, the definition or the term navigable, and he's right. I hope my paper or the co-authored paper doesn't make this mistake of suggesting otherwise. I know that the term navigable wasn't fixed by the Daniel Ball case, right? That in subsequent Supreme Court cases, including Riverside Bayview, which we discuss in our paper, that the Supreme Court said it is more capacious than what we thought in the 19th century. But I also appreciated Rob saying over and over again, we were talking about a more functional definition of the word navigable. Navigable, the word in the statute, I think has to be the touchstone of any meaningful good faith analysis by the EPA and the Army Corps. And so when Nathan was talking about the line drawing, a possible line drawing, like the ecological line drawing or the property rights line drawing, I understand those debates, but I think they all have to come after this initial legal debate, right? And I think that, for example, the ecological line drawing is exactly what I was trying to get at in my initial paper, or my initial talk. Sure, all waters are connected in some way, right? We all learned that in the second grade, right? But if that's what Congress wanted the agencies to go about and deal with, then why write a term like navigable in the statute? Yeah, it's a broad term, but they at least took the time to put that word in the statute. And that word should be taken seriously, navigable. So I think I agree with Rob that ultimately the touchstone has to be some version of navigability or something related to that. That has to be the beginning of the conversation. These other debates, I think, have to follow after you grapple seriously with navigability. Two other really quick points. I was really struck by Nathan's point that the constitutional debate or the constitutional issues are a sideshow. I sort of chuckled when I heard that because I'm in many ways a conventional conservative Republican with conventional conservative Republican views. There's so many policies for which I would like to say, your constitutional concerns are a sideshow, and let's talk about other things, other policy trade-offs, and not get bogged down in constitutionalism. I think the constitutionalism here is important. Federalism is a core value of our Constitution, a core structural value, and I think it has to be taken seriously in the interpretation of this statute. I'm not saying we throw this all to the courts to decide this all on federalism grounds. My friend Clark Neely is sitting here in the second row. He knows better than anybody that I am not one to throw things into court. Maybe I'm too chicken about this now. But I think at the very least, those principles should inform the legislative and administrative debates, and that's basically all that I'm asking for. One final thing, it wasn't my paper, but I do want to touch on it because it's an issue I worked on in private practice before I joined up with Boyden. I worked on the failed challenge to the last California waiver decision, and it's an issue I follow closely, I care deeply about. The negotiations leading to that Rose Garden deal, they were nothing like the spin that was later put on it by people like Jody Freeman, who's now a scholar at Harvard, but who was in the White House at the time. If you read the House Oversight Committee's report from 2012, citing the emails that Freeman and Carol Browner sent to the auto companies, quoting people like the reporter from Edmunds, the editor-in-chief from Edmunds, who said the auto companies felt like they had a gun to their head. When you had emails from Freeman and others at the White House telling the car companies that they had 24-hour deadlines to sign these pre-written commitment letters with no edits by the auto companies at that point. Was it legal or not? I don't know. We have negotiated rulemaking statutes and a process to make sure that when we allow major issues of policy to be settled through negotiation, that it's done transparently and equitably. The CAFE deal was an abomination. I wrote about this in National Affairs magazine a few years ago, detailing this. It's what I think it's one of the worst examples of White House bullying of the regulatory process and regulated entities. And so I would really urge you, if you're interested in this issue, go back and just read the House Oversight Committee report. It's pretty shocking.
All right, let's hear from the audience. All right, question up front.
One thing that didn't really come through, I think, in the talk on the California issue is that it's not just California, right? It's under the Clean Air Act, a bunch of states that are non-attainment can adopt California's standards. And when we're talking about a corporate average fuel economy standard, that means every state can have its own corporate average fuel economy standard, and every automaker has to plan their corporate strategies according to the strategy of that state in order to sell vehicles nationwide. So right now we have a system where California has promised that it will have a California standard in those states. So those states have pooled their corporate average fuel economy standards together, but that's just by California's grace. If California wanted to, it could get rid of that, and then all of a sudden you have every single state having a corporate average fuel economy standard of their own. And not only that, but every state can decide whether it wants to pull out, if say the Republicans take over the state legislature, every state can decide whether they want to have a corporate average fuel economy standard or not. So maybe all of a sudden a state pulls out, and so all the vehicles sold in that state are no longer subject to the California standard. It's a complete chaotic mess. So Congress wrote this clear preemption provision to avoid precisely that problem. And that's exactly what they're trying to get around. So I don't see how you can say that there wasn't a legal problem here. It seems to me there's a clear legal problem. And if you actually look at the benefits of California going alone and having its own more stringent, let's say, greenhouse gas program, it's completely irrational. Because if California goes ahead and does this, what's going to happen is car companies are going to sell less fuel-efficient cars in other states because they're subject to this national fuel economy program. So what would have happened if there wasn't a national program and California went on its own is that effectively would have almost zero benefits because automakers would have sold these cars that have terrible fuel economy elsewhere in the country, and you would just have these cars that have great fuel economy in California, which would be a perfectly irrational way to run the country.
I'll just have a couple of words to say about that. I guess I'm not understanding how it could work out that you'd have standards in states other than California that differ from both the California standard and the EPA standard. Statute is quite clear that California can apply for a waiver and get permission to adopt a more stringent standard than EPA, and that other states can then piggyback automatically onto California's standard. So the way the statute is designed is, at a maximum, two standards, the federal standard and California's. The scope of the more stringent California standard is going to differ depending upon how many individual other states decide they want to piggyback on California's standard. If, in fact, a state other than California wants to adopt a standard that's different from both the federal and California standard, that's preempted, in my view. But I don't understand how that would be accomplished.
Yeah, so they would adopt the same standards as California, the same corporate average fuel economy standard. It would just be a separate, right? So if you adopt the same standard just for my state, but it's a corporate average fuel economy standard.
Right, but why is that different from California's standard?
It's not different. You just have to meet two different corporate average fuel economy standards in each state because they're based on the amount of sales you have in each state.
Let me say one other interesting thing about the California waiver situation, and again, I'm not an unbiased spectator here. I was involved in the failed challenge to that waiver. As Rob correctly said, California has this special waiver authority basically for two reasons. One is it was an innovator at the time of the passage of the statute for cleaning up the exhaust from cars. And second, California's topography creates very specific California-specific problems, right, smog and so on. And so it makes sense for California to have the authority, or for the EPA to have authority to waive California's different standards so that California can solve these California-specific problems. The 2009 waiver decision from the Obama administration, the one that the Bush administration had refused to grant, was fundamentally different because we were no longer talking about California-specific problems, right? The entire purpose of resolving smog and so on, the ozone problems in California, climate change is a completely different problem. As we all know, climate change is a global issue. It doesn't have California-specific impacts based on the emissions coming out of cars in California. And so you had a very specific statute for a very contextual problem suddenly being stretched over time to give California the power to threaten this two-standard patchwork, right, which as the House Oversight Committee report makes clear, was the leverage the Obama administration used to get the auto companies to the table, that and the auto bailout, to create, again, the situation that was reported as auto company executives feeling like they had a gun to their head. Again, I'm not saying that the administration couldn't do this. They obviously did it, but it's no way to run a country. I think it's a very problematic approach.
Just to say for the third time, don't forget the other statute, which is more directly aimed at this problem, which is a flat-out preemption provision. Flat out. I mean, there isn't any waiver authority in EPA to do or not do. This is a flat-out preemption provision, which hasn't, which you guys haven't talked about, and you know, I just don't see how the Supreme Court could have ever allowed that preemption statute to be ignored.
Let me take a cheap shot and then make a point. So the cheap shot is that I'm shocked to see such criticism of environmental federalism in this room, to allow each state to set a different standard. The Clean Air Act, or this part of the Clean Air Act, is unusual compared to other federal environmental laws in that it does explicitly preempt the ability of states to write stricter standards. Our general approach in other Clean Water Act, for example, is that states can set stricter water quality standards if they want. We don't let that happen with motor vehicles because we have more or less a national market for all the reasons why that makes sense, and I don't question that. But the point I want to make is that there is no combination. There's a maximum of 2 standards, and the minimum size for the California standard is some group of states that includes California, a state whose economy is larger than that of Canada's, a country in which every U.S. automaker successfully competes in the market and sells cars. So I don't get the tears about not being able to deal with a 2-standard setup in the United States when the minimum size of one of those standards is so large. I suppose you could come up with a scenario where every state except Alabama picks the California standard, and then Alabama stays with the less stringent, not to pick on Alabama, by the way, Alabama stays with the less stringent federal standard, and then that's a tiny market. But then all Alabama has to do is adopt a more stringent standard. And that's, in any case, not the environment that we're in. If California is the deviator, California is a large enough economy on its own to support a major international car maker.
Let me just repeat that it's one thing to have two different cars with 2 different kinds of catalytic converters. It's another thing to mess with the with the basic makeup of the car, the wheel span, the size. That's what's impossible, and that's what I don't think your response encompasses. And for the 4th time, there's that other statute and other department, which I guess nobody likes to recognize because the EPA is all powerful and all godly in all respects.
Can I just ask you a question, Ambassador Gray? As you read the Energy Plan and Conservation Act provision, does it override the Clean Air Act waiver provision?
Of course it does.
Okay.
And I can't help but jump at the bait. I don't think Nathan's point was a cheap shot. I think it's a fair shot, right? We spend some of our time here talking about federalism, devolving issues down to states. Other times we're sitting here saying it's a national market, national standard is important. That's a fair criticism. I think the key, though, is looking at the balance that Congress struck, right? These things that we're talking about federalism, in my life as an energy lawyer, I was going into federal court calling for states to be, for their state laws to be preempted when they were interfering with the navigation of ships on interstate waters. It's a big part of my practice. That's why I understand this. I think ultimately it comes down to what balance Congress struck, whether it was in the Clean Water Act or the Natural Gas Act or EPCA or any of these statutes. I think it ultimately has to come back first and foremost with Congress's decision, with an appreciation of these constitutional values undergirding that decision. Things that don't dictate how to interpret the statute, but should inform how to interpret the statute.
One final point here about the 2 conflicting waiver or preemption provisions. I've never really focused, I have to admit, on the Energy Policy and Conservation Act provision. My recollection is that statute was passed in 1975. Clean Air Act waiver provision was adopted in 1977, so you have different canons, 70?
1967.
The relevant part.
But the relevant provision was 77. If that's true, then you have conflicting canons of interpretation here that might bear on which one takes precedence. There's one canon that says the more specific overrides the more general. I don't know which one that would be, but it could be the EPCA statute. Another says if there's a conflict between two statutes, the later adopted statute supersedes the earlier adopted statute. Finally, the courts struggle to accommodate two apparently conflicting statutes in a way that will give force to both of them. And so I don't know how the court would come out if faced squarely with the question of whether these two provisions conflict, and if so, which one takes priority.
Question in the back?
Yes, to Ambassador Gray's point about the preemption, this was a matter for congressional hearings, and the EPA administrator and the assistant administrator could not give a straight answer to the question, how do greenhouse gas regulations of automobiles differ from fuel economy standards? All they could say is, well, they're not identical. Well, in fact, in practice, they are identical, and the EPA was trying to get around the preemption, which they admitted was the governing principle, until we claimed this fantasy that regulating greenhouse gas emissions from a vehicle is different from regulating the fuel economy. So I think Ambassador Gray is exactly right that the preemption is the governing principle.
You know, this was one of those issues that the Supreme Court sort of breezed through in the Massachusetts versus EPA case. The Bush administration in that case had stressed that the Clean Air Act was one of several statutes touching on this issue, that there would be real problems of agency coordination. And the Supreme Court has a line in Massachusetts v. EPA. I can't remember exactly what it is. It says, we see no reason why these agencies can't find a way to peacefully coexist. And I think that was maybe a little bit too glib. It reminds me a bit of the way the Supreme Court had to sort of walk back a little bit or clarify or draw distinctions later in the follow-up case, utility or regulatory group, where they had to say, well, sure, in this one context, the Massachusetts v. EPA, Title II, mobile sources, it made sense to construe pollutant very broadly. Over in this context here, with stationary sources, we do need to draw finer distinctions. Some people accuse the court of sort of reverse engineering an explanation for the different treatment. But the fact is they had to, if it was a reverse engineering, they had to do so to make sense of the statutes after they breezed through everything in Massachusetts versus EPA.
Question in the back?
Hi, I was curious whether you thought it was likely that EPA will try to rescind California's waiver authority.
Say that again?
I was curious, or to revoke EPA's waiver authority.
Will EPA try to revoke the waiver?
Yeah.
I mean, they can't revoke the authority, right? It's the EPA's waiver authority. They're the ones waiving federal preemption of state law by the Clean Air Act. So that's going to be there.
Every time EPA issues a new set of fuel economy standards, California has to apply for a new waiver. So the question would be, the next time they issue a standard and California applies for a waiver, will they deny it? And Administrator Pruitt has testified before Congress on this at least a couple of times in his confirmation hearings and then this week. And both times, first time he said, I see no reason to do that now. And I think this week he said, it's under consideration. We haven't reached a decision. So I don't know where we're going to wind up.
Just to repeat again that the point that Adam was making, that CO2 is not a criteria pollutant. Just want to emphasize that. It's not a criteria pollutant. It never will be.
There's some questions over here.
I think I'll give this to Mr. Richardson. I'm a little disturbed about the point you're making where the government had a right to impose regulatory conditions in negotiating the investments that it made in the wake of 2008. For my understanding of that situation, and Ambassador Gray mentioned this with respect to Ford, is, all right, General Motors failed. The government had to advance funds to General Motors to put it back on its feet, thereby avoiding social welfare bills that would have come due if there was a disruption of a bankruptcy while the situation was going through bankruptcy. So the government certainly had reasons to be doing that for purposes of maintaining employment and various other things. Now, if you're Ford, what the hell do you do with a competitor that the government now is running, owns, appears to have zero cost of capital, its debt is being taken away? I mean, this is a lot of the reason why this whole business of the government in investing in these companies is hugely disfavored. You know, when they had to do it for some entities like AIG and General Motors, they got out of those things as quickly as possible because the danger of this is immediately apparent. So it seems to me it would behoove the government, if they were going to engage in this sort of emergency operation, to have as light a footprint as possible. And just from a policy reason, using it instead as some leverage point to, you know, press regulatory measures across an entire industry, which you're barely able to get through under other normal legal regimes, that does not sit very well with me.
Let me, I think, half agree with you and half make you mad. I share a lot of your worries about large direct government investment in major companies. And we were talking about funding basic research or other government, cash interventions into the economy. I have less problem with that. But essentially turning a major automaker into a state-owned enterprise or something like it, I'm troubled as well. And you could probably convince me that that was a bad idea. But once government has opened that door, I'm okay with them using that authority, whether we characterize, using that opportunity, whether we characterize it as government acting as an investor and therefore playing a role in the management of that company, or whether we characterize it as government providing a benefit that comes with some conditions. Either way, I'm okay. I would prefer, for the reasons you suggested, that it be short-term and question whether we should do it at all. But once we've done it, if the goal is to achieve purposes that benefit the public, which I think most people, perhaps Ambassador Gray is skeptical of electric vehicles. I think we know that. But at least the purpose behind this is to manipulate the market in the way that is believed will create long-term public benefits. And I think at least it's sold. And if you look at the testimony of the auto executive, sold as it would increase the long-term competitiveness of the American auto industry as well. It's not just about public goods, but also about some private goods as well. I'm okay with that once we're in that door, even if I share a lot of your concerns about whether the government should go through the door at all.
But the way you phrased it, we walked through the door of the government bailout and now we're going to sort of make the best of it. I genuinely don't think that was what really happened. President Obama had campaigned in 2008 saying we need to make a deal with the auto companies. We will relieve them of their pension burdens, their immense pension burdens, in exchange for them signing on to major health care reform. Campaign on this, that we're going to make a deal with them. He was already, he and his administration were already thinking in these let's make a deal terms up into the election. He was elected in the middle of the financial crisis with the auto companies totally falling apart. He saw more than an opportunity for just a chance to make an offer, make a deal. He had an opportunity to make an offer they literally couldn't refuse. Right? And so I think we need to take a step back and think of it less about, you walk through the door of solving the crisis, then you make the best of it. I think you need to find a way to keep the door shut, right? So that we don't allow government to sort of walk into these circumstances where it can leverage one power in a way that might have some real perverse incentives.
Thank you. Adam, I want to see if I can get you to take your observation one step further. You noted that as Congress is more and more incapable of legislating. The agencies fill the gap, but that almost suggests that it's a benign gap or maybe a beneficial gap. The other principle I'd like you to comment on is that over time, when an agency has a regulatory program, it will interpret that program to aggrandize its power, supplement its staff, justify its growth. And I think the WOTUS is a perfect example. Nathan suggested that it was trying to do its very best to interpret the Rapanos case, but the evidence I'm aware of is much stronger that it said that. It said it was seeking clarity, but it was seeking intentional ambiguity to increase its power. It took, instead of the Scalia opinion, which really is the controlling opinion, I know that's hotly debated, it took the Kennedy standard and twisted it and made up its own Kennedy primed. It declared in Alaska that permafrost was a navigable water of the United States in its Alaska supplement. Its abuse of the Johnson case that you cited was not accidental. What's consistent about every single one of those decisions was that it increased the agency's power. Isn't that another principle of the administrative state that we need to address and deal with?
Right, you put it better than I could. I mean, whether you want to talk about it in terms of public choice theory or whatever, there's a reason why we call these entities regulatory agencies rather than deregulatory agencies, right? They tend to be imbibed with a mission that goes beyond just the specific words of the statute. All of their errors tend to be mostly, I shouldn't say all their errors, sometimes agencies do want to regulate, but I'd say on the whole their errors tend to be in the pro-regulatory direction less or more than the under regulatory direction. It's not just the agency's incentives that are misaligned here. In addition to that, in addition to the problem you point out, there's Congress's incentives. You know, I run a center here called the Center for the Study of the Administrative State. Not the Center for the Administrative State. Rob runs that one. Kidding. I only say that because Rob's a friend. My predecessor, the professor who founded the center, Naomi Rao, wrote a really great paper a few years ago on considering Congress's incentives in delegating power to agencies. That Congress itself has, and individual congressmen and committees have incentives to over-delegate. I don't know if that's a problem the courts can solve, but I think it's a problem we need to analyze. And Congress sort of handing off its own authority for reasons that really don't reflect, I think, the framers' vision of ambition counteracting ambition. You know, Madison talked about Congress being, what do you call it, an insatiable vortex or something. Those are the good old days. Right now, we wish that Congress had a little bit more ambition than it has.
Two points in response to John's question. Number one, there was at least one example where they took the narrow view, and that's with respect to groundwater. They disclaimed jurisdiction over groundwater. So had they accepted jurisdiction over that, it would have been a more expansive set of authorities. But more generally, the point you bring up is an extremely important one, and it was starkly presented in a Supreme Court decision called City of Arlington a few years ago, where the question was whether courts should defer to agency interpretations of statutes that bear on the scope of the agency's jurisdictional authority. Chief Justice Roberts wrote an impassioned opinion saying that deference was not due. He was in the dissent, however. The majority opinion coming out the other way was written by Justice Scalia.
I think we have time for one more question.
Just one point, and then I'll ask my question. EBCA says related to fuel economy, not identical to fuel economy, just for the record of EPA up there. My question is, we've talked about federalism and the California waiver. So my question is does anybody think, or is it plausible to think that there is sort of a real federalism problem with the California waiver? So we have this model in environmental law where it's called, we call it cooperative federalism, and you can either implement your own standard or the federal government gets to do it for you. But what we have in California is you can either implement the federal standard or implement California's standard, which seems a little off, at least from sort of a traditional federalism perspective. And you also have this sort of equal footing problem where you have a state that, right, is effectively has all this power, and all the other states are prohibited from exercising their own sovereign power to regulate motor vehicles. So how does that fit with sort of the Shelby County equal footing doctrine, and how does it fit with cooperative federalism?
I mean, I don't think there's any question that regulating maybe there's a question, but I don't think there is a significant question that Congress would have the authority to write the statute such that states were completely preempted. It's when they're within their Commerce Clause authority, at least with respect to motor vehicles. So, and because of that, it seems like a lesser included power would be to allow a limited exception. I guess that's my read on it, that it doesn't trouble me, because if it were a situation where it was much more ambiguous whether Congress, if we were more in the waters of the United States question, where the boundary of Commerce Clause power is more ambiguous, it might trouble me more.
Do you want to say anything?
Well, I just note the distinction between stationary sources and mobile sources. Stationary sources which contribute to local pollution problems can be granted sort of federalism deference, I think. But the reason why the EPCA preemption provision is so strong is because cars are sold in 50 different states, and there really can't be any variation in the basic structure of the car. There can only be really one, and that's why the preemption provision is so strong, because fuel economy is so integrally related to how a car is built. It's not like putting on a four-way catalyst as opposed to a three-way catalyst.
Let's say, in the interest of ending on a conciliatory note, I agree with Nathan. I think that this is an issue where, of course, there's federalism concerns, and I think the patchwork is a real problem for the reasons that James pointed out, but ultimately there are lines that Congress gets to draw.
All right, why don't you all join me in thanking our panelists for this lively discussion.
Okay, so on behalf of the Journal of Law, Economics, and Policy, thank you very much for attending today. And we also want to thank the LEC and the Federalist Society for co-sponsoring. And we especially want to thank our authors and our presenters for sharing their thoughts on regulatory reform. And your thoughts have given us a lot to think about. And the Journal looks forward to publishing these papers in an edition later this spring. So thank you very much. And I think that Greg gets the last word.
I often do. I, too, would like to thank you all. That's not me, is it? That would be embarrassing. It's not me. Thanks especially to the authors and the discussants. The authors at least have a self-interested motive to be here to pitch their work. The discussants are the real heroes to come in and help us all put their work into some context and give us some lively, invigorating discussion. But I'd like to thank all of you for joining us on a Friday, particularly late on a Friday afternoon, to come out and talk about what are obviously quite important issues. I want to point out just a couple of people to draw some special recognition to. Bonnie mentioned the Federalist Society, Devin Westhill, Gene Meyer, Dean Reuter, who have been wonderful to work with in this whole process. Obviously, the staff of the Journal of Law, Economics, and Policy, and on my staff, the Law and Economics Center, Jeff Smith, Amanda Olsavsky, Sasha Packer, Diana Davis, and Ryan Lodata have all made what to you all hopefully seemed like a seamless and wonderful event. Behind the scenes, believe me, it's a lot of work to pull off an event like this. So thank you all for coming and sharing your time with us. I hope you will stick around for a little while now to join us for a reception just outside in the gallery. So thank you again.
Thank you.